Michael J. Norton is my name. Mike, as you know me by. I am Senior Counsel for Alliance Defending Freedom. Alliance Defending Freedom is an organization that is designed to defend faith and freedom. We've been in operation and existence since 1994. We were launched in 1994 by a number of religious leaders in our country who saw that Christians, people of faith, were not even showing up for the constitutional battles that had been going on since really the mid-1950s. And we were essentially abandoning the effort to people like the American Civil Liberties Union and organizations of like views. So Alliance Defending Freedom was formed and launched in 1994 for this specific purpose of combating these efforts and bringing the Christian worldview to the marketplace, to the public square, and to the constitutional legal arena. We focus on traditional religious liberties, First Amendment free speech issues. We focus on sanctity of life, and we focus on marriage and the family, the traditional view of marriage being one man and one woman. In this case, we represent Hercules Industries, which is a small, Denver-based, family-owned business, been in existence for 50 years, founded by the Newland family 50 years ago. And the Newlands, for as long as they have existed, have been strong believers of the Catholic faith. And they have attempted over the years to implement the tenets of their Catholic faith through the practices of their business. And that's the way they treat employees. That's the way they treat their customers. That's the way they treat everyone they come into contact with. But by virtue of their strong Catholic faith, through their business, they had objected to and not desired to provide health insurance coverage that would include abortion-inducing drugs, contraception, and sterilization.
And we should be clear here that that's just the insurance coverage that they're buying. They have no objection to an employee on their private time or private money buying whatever they want to buy.
This isn't about whether they object to employees gaining access to those things on their own. It's just who pays for it. And as a matter of faith, the Newlands did not think it was right for the federal government to force them to include in their health insurance, very generous health insurance plans, I might parenthetically add, very significant coverage of catastrophic injuries, of pregnancies, of well women exams, of very beneficial things of need to the employees. They're self-insured, and so their plan was going to have to include these types of things that they object to, the abortifacients, the contraception, and the sterilization, effective actually August 1, and their new plan that would have gone into effect on November 1. Well, first of all, the regulation was issued by the U.S. Department of Health and Human Services requiring coverage of abortifacients, contraception, and sterilization. It stems from the Obamacare law that provides for coverage for preventative health issues relating to women. There's nothing specific in the Obamacare law that provides for abortifacient contraceptive coverage, but HHS took that sort of generalized women's health issue and translated into a business requirement that businesses provide for abortifacient coverage. Now, the question was, I'm sorry, I kind of lost track of the question, but this was a mandate by HHS on these businesses that was very, very poorly defined, but suddenly they were faced with a decision: do we implement this mandate, or do we resist it and file suit in court? And that's basically what they did.
And there was an exemption that was very narrowly defined.
A very narrowly defined religious exemption if for churches and synagogues and places of faith where people practice their faith and worship were carved out in exemptions. But in addition to that, and what I think this Judge Kane, found to be very telling and persuasive in his ultimate decision, was that there were also lots of other exemptions from coverage given to businesses and others from the coverage of the abortifacient requirement. And so it wasn't exactly a universal coverage issue, even as it applied to private businesses.
Maybe you can clear quickly, as we just take a short detour, and you can clear something up for me. My understanding is that the definition of religious institution that they are using doesn't have an antecedent. They're not pulling it from someplace else. They sort of made it up.
It's very curious. This administration defines exercise of religion as essentially right to worship. And the right to worship to the Obama administration appears to mean what happens inside the four walls of one's church, one's synagogue, or one's place of worship, or maybe even one's home. It doesn't happen in the marketplace or in the public square. People are not, therefore, able, under that definition, to take their faith with them and use it as guides for how they act in public. And that's really what this is essentially, bottom line, all about.
I mean, just from a legal point of view, I'm correct in understanding, because when I looked at the reg, I didn't see where they were drawing it from someplace else. It seemed to me they were just sort of
it's made out of whole cloth. It really is made out of whole cloth.
Good.
First of all, we filed a complaint a few months ago on several bases alleging violations of federal and constitutional laws. The law that we alleged was violated is called the Religious Freedom Restoration Act, or popularly known as RFRA. This is a law that was passed in 1993 by the United States Congress, signed into law by President Clinton, almost unanimously passed by the Congress, to require that government actions that impinged upon the exercise of religion had to state or provide for, first of all, a compelling governmental interest, and secondly, had to be implemented in what's called the least restrictive means possible. So first of all, you had to have a compelling governmental interest. It didn't matter whether it was a law of general applicability or a neutral law. If it impinged on one's religious exercise, then secondly, the government had to show that it was the least restrictive means. The way in which the law was implemented, or the compelling interest was implemented, was the least restrictive means possible. So that's the statutory violation that we allege, the violation of the Religious Freedom Restoration Act. We also allege that there were violations of the First Amendment Free Exercise Clause, as well as the First Amendment Establishment Clause. Now, yesterday, Judge Kane, actually Wednesday, Judge Kane in the United States District Court for the District of Colorado held a 2-hour hearing on these issues. He recognized, as we requested in our moving papers, that it was very important for there to be a hearing and a ruling by August 1, which is the date on which the HHS mandate went into operation and was effective. Secondly, he recognized that the Newland family and Hercules Industries was faced with the need to craft their next year's insurance plan, effective November 1, 2012, within these next period of time, so that they had to have time to plan what would be in that plan, that insurance plan, so as to make it available for employees to be able to select to go in the plan or not. There's really only one plan. It's not like multi-plan selections that might be available to some employees in some situations. This is the only plan, so the employees would have to be able to select in or not of the particular plan. So Judge Kane listened to the evidence, the testimony, as to whether or not the HHS mandate should be imposed against Hercules Industries, and decided in a ruling issued today that yes, it should. It did infringe upon the religious liberties of Hercules Industries and the Newland family, and it should be enjoined from going into effect, at least until there's a resolution of the case on the merits. The preliminary injunction, first of all, the issuance of an injunction by a court, a preliminary injunction by a court, carries with it a very heavy burden of proof and very significant standards to overcome. You have to show actual and imminent injury. And that's what the Hercules Newland family did by showing that their religious rights and liberties were being infringed. You have to show probability of success on the merits. And Judge Kane concluded that based on the evidence before him, the Newlands and Hercules Industries have a very good chance of succeeding on the merits. You have to show that there is no alternative to the remedy that you're seeking other than injunctive relief. You have to be able to show that you couldn't resolve the issue by, for example, a grant or an award of damages. There has to be no alternative remedy. And secondly, you have to show that it's in the public interest and a balance of the equities for there to be an injunction to be issued. Judge Kane found, generally speaking, all of those factors had been met by Hercules Industries and the Newland family, which was the reason for the issuance of what is called a preliminary injunction. Now, under his order, the preliminary injunction remains in effect for a period that includes 90 days after the resolution of the underlying dispute on its merits. So that begs the question, okay, what happens from here? And what happens from here is somewhat speculative at this point in time. Preliminary injunction order that has been entered is an appealable order, and the Justice Department could elect to appeal that order. The United States Health and Human Services and the other defendants that are named in the complaint could elect to appeal that order, in which case it would be appealed to the 10th Circuit Court of Appeals. They could elect to do nothing and proceed to seek to have the matter tried on the merits, so that there is a final trial on the issue and thus a permanent injunction being entered by the court or not down the road. No trial date has been set, but under Judge Kane's ruling, a case management conference order has been requested. I think it's by August 30th or something. Yeah, you were asking me about whether or not Judge Kane's opinion, if it is rendered as a final decision, has any precedential value as to other cases. Judge Kane, in his preliminary injunction order, was very careful to state that contrary to the worry expressed by the Justice Department in its briefing, this case is limited to the facts of the case as well as to the parties, that is to say, as to Hercules Industries. And that would generally be true with any district court opinion, whether a preliminary injunction or a permanent injunction. It would be limited to the facts of the case and to the parties. And so it would not have precedential value as to, it would not be a binding precedent as to other similarly situated plaintiffs or parties, not even really in the District of Colorado, but around the country. That said, it would have very significant precedential value. It would have very significant persuasive value. It would be very persuasive to other courts in other parts of the country as to why Judge Kane found what he did and how he got to the conclusion that he did. So I think it's a very significant decision for Alliance Defending Freedom, and more importantly for Hercules Industries, and more importantly for religious liberties. There are really two major ways that employers offer insurance to employees. One way is through private insurance carriers, where people will go out, where an employer will go out and find, get bids from Blue Cross Blue Shield or competitors to that, and offer those kind of plans to their employees. The second is for employers, and those that many employers do it this way, self-insure. And so they put together an insurance plan. They put it out for bids to insurers, and the insurers take a look at the terms of the plan. That's why it's important to know what's going to be in the plan now, since this plan goes into effect November 1, and really has to be in place by October 1. They put it out for bids, and insurance companies come back and give bids on, we'll cover those benefits in this insurance plan for X price. And then the company has an excess insurance coverage as well in case of catastrophic injury. So if there's greater than anticipated loss on a particular employee within the plan year, they'll have some excess coverage for that purpose as well. So that's how a self-insurance plan works. And self-insurance plans are regulated under Department of Labor guidelines called ERISA. And so that's really how the Obamacare HHS mandate comes into being in this case, because any plan that is regulated by ERISA must also comply with the HHS mandate, and therefore the plan itself must include, unless otherwise ordered, as is now the case with Hercules Industries, must include those abortion-inducing drugs and related services. And nobody's, it's not one of those things where there's this great outcry for abortifacients and contraceptives, because they're readily available. That was one of the things Judge Kane pointed out in his order. There are all kinds of government programs in existence today that provide essentially free or at little or no cost abortifacients and contraceptives and sterilization. Title 19 Medicaid is one of those plans. Title 10 Family Planning Block Grants is another such plan, and likewise Title 20. And then the states themselves often have additional plans on top of that. So these services are readily available at no cost now, and there are lots of different ways the government can make abortifacients available to people without imposing that obligation on people of faith. And that's a very, very important consideration, because the fact is that the fines and penalties that the HHS mandate would impose on Hercules were to elect not to comply with the mandate, were obliged to comply and elect not to comply, are crippling. It's been calculated by a couple of different sources that the fines in the case of Hercules Industry would be $9.6 million per year. Huge taking of the value, the worth of and the equity of the company, probably putting it out of business, quite frankly, if it were to have to comply with those, if it were have to pay those kinds of penalties in lieu of providing against their conscience the insurance coverage that HHS mandate requires. First of all, it's a small, privately family-owned S corporation owned by the Newlands. There are maybe 7 members of the family that are the owners of the business. That financial information is not a matter of public record, nor is it required to be a matter of public record as a public corporation, for example, would be. But a fine or penalty, however you want to characterize it, of $9.6 million,
or a tax,
but no matter how you want to characterize it, would put the company out of business.